In the matter of the Castlepoint Borough Council and another.
Yes, very good.
May it please you, my lord, I appear in this matter together with my junior, Mr. Williams, Mr. Daniel Stebbins-Jones, together with Mr. Tom van der Kloek, appear on behalf of the defendant.
Right.
The interested party is not present. My lord, we checked, and as far as we know, the court now has all the materials that it requires for today, so the core bundle, supplemental bundle, skeletons, and the bundle of authorities as well. I'm very grateful. My lord, you will have seen the competing propositions.
Yeah, and I'm sure the parties, you will understand, but the parties will understand that we've read the papers in advance, so we take these cases on that footing.
Yes. And so...
my lords, just while we're on whether you have everything you need, there's just one addition, which is a paragraph of the MPPF, which should have been included, that follows on from. I've mentioned this to my learned friend who agrees. It should be in. It should be behind page 46.
The supplemental bundle.
This is the core bundle.
Core bundle.
Core bundle, page 44.
Yes.
You'll see extracts from the National Planning Policy Framework.
Correct.
And you'll see paragraph on page 43. You'll see at the bottom paragraph 178, and then on the following page it goes through to paragraph 182.
Yes.
There is a 183, which is on the next page of the MPPF, which is relevant, indeed relied upon.
So can you hand it up?
So I have copies here.
Are they hole punched?
They are hole punched.
Yes,
we would probably need to create a page 44A.
44A. Okay.
Let me hand these.
Okay.
I'm grateful, my lords, and apologies for the interruption.
Thank you.
Thank you.
Yes,
So,
indeed.
my lords, until I get back to the judgment of the learned judge below in the core bundle, most of my references will be to the supplemental bundle, so that's probably the one that it's easiest to have close at hand. But just before we do that, on the core bundle, and just so that my lords relocate where they are, as it were, the grounds of appeal Lord Justice Lewisham gave permission for, pages 17 to 19 of the core bundle. The MPPF extract that my learned friend was just referring to, title page at 42, and then the relevant provisions of national guidance, as my lords appreciate, carrying on from pages 43. And then part of Circular 1195, which again foreshadowed in my skeleton argument, whilst the circular, as it were, it has long since been revoked. In fact, the model conditions remain in force, and so the model conditions that we have shown at the court and we showed the judge, just for illustrative purposes.
So where are you reading from?
I'm in the core bundle, pages 46 and 47, just following on from the MPPF.
Yes.
And so they're typical examples of the kinds of model conditions that can be imposed in cases involving contaminated land. And then the judge's judgment, of course, from pages 67 onwards. And so, my lords, within the skeleton argument, I endeavoured to set out in some level of detail the factual background with page references. One of the important pages, which, if it were a clearer and better copy, and it's not always easy to get good copies of these things, which would have shown the previous as it were, state of the fencing before the planning application is now in the supplemental bundle for all of these references. Behind, if my lords have tabs, it may well be behind tab 10, but this is the Planning Commission, CPT 1602 FUL. And attached to that, hopefully at 336.
Just while we're on that,
yes.
What's the planning application at 159 relates to Unit 10?
Yes.
So I thought it was Unit 16, which was the relevant
it is Unit 16 that we are dealing with, but Unit 10 also got a permission.
It is part of the dogleg shape, isn't it?
Exactly.
Yes.
Yes. So they're set to work as one unit.
It is a relevant planning application, that is it?
Yes.
Even though it relates to Unit 10.
Yes.
All right.
And so what we see here on
So where do you want us to go to?
page 336, just to see the plan,
Hang on,
which, as I say, presumably in its original form at A1 or perhaps A0, would have shown clearly the various enclosures as they then were, but they are described in general detail at paragraph 12 of the skeleton argument. So the chain link fence between our land and that of the interested party on the northern boundary, and then references to the concrete panel fence at a height of 2 metres at the southeast corner, which of course on this plan is the top right corner, and then sheet metal fencing of a height of 3 to 4 metres northeast, top left and northern middle, so running along a fair portion of what on this plan is the top boundary. And you all the benefit of the photographs that were taken on behalf of the objector, now claimant, at various points in time. I'm sure my lords will have taken a moment to look at those photographs and see what they demonstrate. So, my lords, unless it's going to assist for me to dwell on the factual narrative that's in the skeleton, I was going to turn straight to some of the central documents within the supplemental bundle itself, run through those and the bits that we
Before
say.
you do that, what are you trying to achieve?
In terms of the...
Do you accept that there should be a proper boundary fence, keeping the site secure, stopping spillage onto your land? Do you accept that in principle there should be?
As the objection accepted, and as I accept, there are potential benefits to having a more robust form of enclosure compared to the form that I've just been describing to my lord. There's no doubt...
So what are you trying to achieve?
To have it done in a way where there is appropriate mechanisms in place that deal with...
But do you agree in principle that it's desirable to have a solid boundary fence?
It might be. It depends on the final configuration. So for example, if having, just for the purposes of the argument, if you have a 5-metre concrete fence that goes along 2 relatively long boundaries of this property, and the evidence shows on proper investigation by the local planning authority that in fact what that will be likely to cause is a much more intense level of activity at the site, or even a significantly more intense, a materially more intense level of activity. And that in turn, if the boundary is not constructed properly, will make the risks of contamination worse. Then as far as we are concerned, and as far as the wider environment is concerned, that would be a bad outcome. So there may be a number of planning answers to that. One might be impositions along the lines of the model conditions.
You want the fence to stay there, do you?
No, but it's a question of what would be an appropriate planning solution.
Well, so what condition should you say should be imposed? You've never formulated a condition. Just tell us what... I know you can say it's not your responsibility to, but I'm asking you to do. What kind of condition you say should be imposed?
Well, my lord, it would depend on what the evidence demonstrates. So if I give my lord an example, if the evidence demonstrated that, say, up to a height of 2.5 metres or 3 metres, which was similar to some of the boundaries beforehand, there would be no materially increased risk of contamination, then that would be an appropriate condition to have. Otherwise, and one of the difficulties we face, and I understand my Lord's question, but one of the difficulties that any neighbouring landowner faces in these kinds of circumstances is knowing at a high level what the implications in terms of contamination may be, but not having access to the site, not knowing in any level of detail what the nature of the workings are on the site, and that being a matter for the local planning authority discharging its functions properly to investigate. So my Lord says, well, why can you formulate the condition now? The condition that the local planning authority would quite often come up with, along the lines of the model condition, is for the applicant for planning permission to devise a scheme so that they can demonstrate.
So you're blocking the question. You are not attempting to formulate a condition. And your answer is you don't need to.
It almost wouldn't be appropriate to at this stage, because the nature of the condition would probably be investigate, assess, and evaluate the risk in relation to contamination, because we know from the officer's report that the officer considered the issues relating to the greenbelt and visual amenity and things like that. So there was enough information to consider that. What there certainly wasn't enough information for the officer to do was reach a conclusion on the basis of whether or not extending to 3 metres, 3.5 metres or 5 metres might make the contamination issue significantly worse. And this is in relation to land where, whilst it's in the green belt at the moment, as my lords know from the planning history, for a long period of time this local planning authority has accepted that this land will probably be the subject of some form of development if it gets its own way through its local planning.
That would be in accordance with the local plan, wouldn't it?
That would be in accordance with the local plan. And the question that will arise is whether or not it ought to be an employment use, a mixed use, comprising some employment and some residential in order to enhance viability of the proposal and so on, or whether it ought to be more heavily balanced towards residential use. But there's no doubt in terms of how a development management officer approaching this should have appreciated the policy context. And the policy context he should have appreciated was that the local planning authority wanted to see development of this land.
Not the scrapyard land, you mean?
No.
Land?
Yeah, sorry, yes, my client's land.
And I mean, the contamination report that we've got talks about the fact that your land fails the environmental tests for residential development.
Yes.
And it's obvious from reading the papers that there's been a complaint in the past to the Environment Agency, I assume by your client. What's happened to that?
The Environment Agency simply were not interested in pursuing it. They have their own policies, their own guidance in relation to these matters. And we tried, we couldn't motivate the agency to exercise its statutory power.
Do you contend that any leakage of contamination is a nuisance or anything like that?
It would certainly be, it would depend on the way that the land was being used, but in terms of private law, yes, it's capable of being a trespass onto the land. It's capable of causing a nuisance in terms of private.
In the old days, it had been pleaded as trespass, nuisance, and Rydens and Fletcher.
Yes, letting dangerous.
But I don't understand this at the moment, just as a matter of common sense. Surely a stout, strong boundary wall should diminish the prospect of contamination.
Well, if it were done right, that may be accurate. The point is that we don't know that at the moment, and the people who are charged with investigating, finding out, and making sure that a contamination condition is met with, that it's monitored adequately.
Is that for the whole site, or is it just for the bit adjoining the wall?
Well, one would...
See, again, you're very vague on this in the objection. Are you saying the whole site should be subject to a condition? So even the bits 30, 40 metres away from the boundary wall?
Well, there would need to be an analysis of the working practices on the site, because as we see from the photographs, there's been a historic practice of mounting scrap metal and other objects very close to the boundaries, and we can see there's been considerable overspill in relation to
So a very good reason for having a good wall.
In principle, yes, but that's one solution to the problem. The other is to ensure that the way that the materials are worked means that there aren't enormous piles of material overtopping
Well, that
the
was what
boundary.
the planning officer said. He said, in the perfect world, we'd have done this properly in 2002. But actually now, living in the world as we are, without the conditions that we could have imposed but didn't in 2002, I mean, you look at the photograph on page 37. I mean, obviously the problem has been exacerbated by the fact that the land has now been cleared, your land has been cleared. I understand that, and there's no criticism of that. But I mean, that's what the collision is. What is the evidence that they are contaminating their land on which the wall is being built, which is the relevant issue for the purpose of the question of construction of the wall?
Yes, well, the evidence that we have of contamination is from the soil investigation report that my lords will have read and seen the level of excavation that was done for the trial pits there. And that, as I say, being put before the local planning authority, it is an apparently clear piece of evidence that if the officer thought they were entitled to entertain and deal with, that would have received a lot more attention. The essential problem here is the one that my lord has quite rightly just identified. Here was a local planning authority that thought they simply didn't have power.
Well, that's what you say.
To address this point.
That's what you're saying.
And I say the report is extremely clear in that respect.
Well, think again. Think again. I mean, you may or may not be right, but don't start using rhetoric like that, please.
Well, my lord, the reason that we say that whatever principle you use to report, and I accept immediately that they have to be read fairly as a whole, using all of the conventional principles. But when the report says in terms there is no planning mechanism to achieve a certain result, then I say that that is a clear statement of what the officer considered the extent of the local planning authority's powers were at that stage. And that is what we say is the essence of the problem in this case. Of course,
Core submission, isn't
now,
it?
that's my core submission.
Yeah.
And in order for the point that my lord makes about, well, what form might the conditions take, what might happen in the future, of course, what we will very rarely in this kind of challenge be in a position to do is, well, we think the local planning authority could only lawfully have arrived at one conclusion. We think they could only have exercised their judgment in one proper way. That would be, as my lord will appreciate, a very unusual case in planning terms. So what we want the local planning authority to do is apply principles correctly. And it might be, again, at the end of the day, that they come back against us on this. And if they did, we'd have to look carefully at whether or not there was some clear legal error in their reasoning process. But we say here there has been a fundamental error based on the case law that is before the court. And it is described by, in essence, the officer saying, well, there is no planning mechanism to achieve what I might want to achieve now, because I can see, with the benefit of hindsight, the words that are used in the report, that it might have been, as it were, a good idea to have a condition limiting the levels of open storage on the site. So that's what was being...
The whole site.
Across the whole site, yes.
Which is what your clients would like. And they'd rather not have the site there at all, I imagine.
Well, the site has a lawful existing use. It is causing difficulties to adjacent land. Those difficulties are in part to do.
Yeah, but let's be practical. If you can achieve a condition which requires, say, the level of scrap deposit not to exceed a height of more than 2 metres, you might make the site unviable. And you wouldn't be sorry. Your side wouldn't be. Your side wouldn't be sorry.
No, but that may be true. I don't have instructions on that, but that is not what is likely to happen through the planning channel. So, for example, the viability of the site is a material planning consideration that can perfectly properly be taken into account.
Yeah.
There ought to be a way, if an appropriate scheme is devised, we would have thought for there to be a proper shielding of any boundary enclosures, so that the risk of any land which is what we say is occurring at the moment, avoided or minimised to the greatest possible extent. And in terms of what a neighbouring landowner seeks to achieve through challenging a local planning authority, in my submission, that is a perfectly proper basis to have articulated the objection that my clients did through the planning process, and then to have pursued the matter further when, if we go to the report, and it may assist my Lord knows what my primary submission is, if we go to the report, consider whether or not there is a sufficient relationship between the intensification that's proposed and planning controls that could be exercised at that stage. That will typically be done by way of...
Sorry, just one other preliminary matter of
Yes.
fact, and then we'll get on with the details. Sorry to shoot all these questions you right at the
Not at
outset of
all,
the program. As I understand it, under the planning permission that's been granted, there's going to be a buffer between the wall and the boundary of, I don't know, some depth.
It's in the order of 3 metres.
3 metres, and no doubt then there'll be landscaping and so on and so forth. Now, could it be said that that will actually reduce the risk? Because under the original planning permission, presumably they could have stored right up to the boundary fence.
But there's no landscaping condition, and the reason that there's no landscaping condition is because the officer accepted what we had said about the relative inaccessibility.
No, but sorry, so if I could just finish right. Under the original planning permission,
Yes.
they could have, on the face of the planning permission, have stored right up to the boundary edge. Yes or no?
Yes.
Is that right?
Yes.
So, therefore, in a sense, introducing a buffer has actually scaled back the area on which scrap will be sited. I just want to make sure I got that right factually.
Well, I'm not sure that follows. And what certainly doesn't follow from my lordship's point is that the volume of stored material along that area would be less, or that the risks of seepage of contaminants would be less. Because if you can store up to, we can do some arithmetic, as it were, without being too detailed about it. But if we look at a 5 metre high wall compared to the previous enclosures that were there, and we accept that that wall is actually robust enough to deal with scrap being stored right up against it, whereas some of the previous enclosures weren't. It simply fell over. Yes. So to that extent, if one were going to obey the law and not trespass and not cause a nuisance, then the ability to get close to the boundary would actually be very significantly less. But
the chain link wasn't actually on the boundary. I think that was the point you'd made, which is it was a bit before, albeit when it collapsed, then split or some scrap fell over onto it.
Yes. But in terms of what could have been done under the permission, then it would have been possible potentially to go further. Perhaps it's operationally interesting that that wasn't what was happening even before, when the previous enclosures were failing. But in relation to the volume and throughput, if one has concrete high structure that is more robust, going up to 5 metres along 2 very long lengths, getting on for 100 metres in one direction and just exceeding 60 in the other, then you can see that by itself is capable of facilitating.
Well, what do you say to the main point taken against you, which is this is all speculation? I mean, if you look at the photograph at page 37 of the supplementary bundle, you've got a fairly good idea of the fact that there's quite high storage of scrap there anyway. There's not much space to put much more if you're going to have the vehicles drive around the site. And what's said against you is that, you know, it is all very interesting, but it's speculative.
Yes, well, what I'd say about that is that it's important always to recall that what an objective is involved in is not an adversarial process, it's an inquisitorial. And so what they will quite often do, and bearing in mind that often they have the level of resources available to someone like my client, they will make an objection pointing out where they think there are policy difficulties with a proposal, or where for other material planning considerations it ought to be refused. And then it's for the authority, of course, to weigh all of those things, and to the extent that it decides it requires further information, it has the powers, as my Lord knows, to acquire that information.
Yeah.
And ultimately, if it's not satisfied, it can decide not to determine.
And alternatively, if as a matter of planning judgment it thinks it doesn't need any more information, that's subject to rationality, its decision.
Indeed. And so if that had been an approach, then I would have been having to meet that threshold. But if my Lords agree or are persuaded that in fact the approach the officer took here was simply to say, I don't think I have the legal power to entertain this, then that is a straightforward misdirection as a matter of law. And the issue of planning judgment does not arrive because it's at that anterior stage in the decision-making process.
Well, I can see the point that intensification is capable as a matter of law of being a material consideration. That's the first stage.
Yes.
But could you just start? Well, perhaps I don't know. Are you going to come on to Penrith sooner or later?
I was intending to do it a bit later, but if the court urges me to do it earlier rather than later, then I will.
No, I'll save my breath for the moment, Mr. Bigham.
So, my Lord, then, bearing in mind the clear steer I've been given about the primacy of the report as against the other documents, can I just go through some of the documents?
Well, that's my personal view, but I mean, if it's not your view, then follow your own course. But...
Grateful, my Lord. So, the planning application, I only need to highlight box 6, and the point about box 6...
So, which page are you reading from now?
But if you have, as it were, the mini tabs behind tab 2, it's tab 1 of that, the sub-tabs.
Yes, right. Yes, box 6, yes?
Yes, box 6, existing use. This is obviously a standard planning application form. Scrap metal recycling, talking about the vacancy of the site, land which is known to be contaminated, land where contamination is suspected for all or part of the site. Proposed use would be particularly vulnerable to the presence of contamination. So those are the questions that are asked there within the standard form and which are required to be answered. And of course, those questions do not apply simply to sites where residential development is being proposed, sites that are derelict, for example, or sites that have particularly vulnerable neighbours. It's an absolutely standard question that has to be addressed so that the authority can arm itself with an appropriate level of information about how to approach the issue of contamination, because it's one of those issues that can be infinitely varied in how it arises and how it needs to be dealt with. And that's why the model conditions go along the lines of suggesting that where there is a potential issue, what is required is investigation, assessment, evaluation, and then the drawing of a scheme that will typically be agreed with the local planning authority. So that's all we need to take from the planning application itself. The planning statement that supported it, one of the plans behind tab 2, we see the new boundaries that are being proposed there. Then behind tab 3, we have the planning statement. And of course, it's worth recognising that the basis upon which this was put forward, and I say the basis upon which it was assessed to the effective exclusion of whether or not contamination should be an issue, is that what was said in 1.1, the dual purpose of the wall is to provide an effective screen being the same height as the open storage on the site and to reinforce security for the yard. It describes the nature of the proposal, and then in section 2 across the page 36, we have the site description. And what can be seen along with the description, but it doesn't appear anywhere in the narrative, it's most clear in the photograph at the foot of page 37, which is still not a good photograph, even if the court has it in colour. But what you can see are the creation of a whole sequence of bays within the new enclosures on both the southern edge and the eastern edge. And those appear to be using the same materials that are being used for the enclosures themselves. And one can see that it goes along the entirety of the southern wall, and then has, for the extent of the eastern boundary that has then been created, there are bays there as well. Now, one of the points that might be made, and until there is investigation, until one knows how the work is being undertaken, and this was a part of the objection, we made all of these points in the objection, one simply doesn't know what the overall result of these enclosure changes might be in terms of the volume of material that can be processed, the tonnages, and the potential implications for the height of storage on some areas of the site, but across the site, including right at our boundary, or very close to our boundary, on the eastern edge.
But as matters currently stand, they can store up to a height of 5 metres.
That appears from the environmental permitting
Yes.
documents, but of course, to put it very crudely, that only matters, certainly only matters as far as my clients are concerned, if the relevant regulatory agency shows any interest in actually policing that particular restriction. And in
Well, the council can't do the job of the Environment Agency.
No, well, quite.
But as matters stand, they are at the moment free to store up to a height of 5 metres anywhere on the site.
Yes.
There's no planning restriction preventing them from doing so.
No.
And there's no environmental restriction preventing them from doing so.
Yes, indeed. And so one of the things that is simply a matter of interest in terms of what was being described and what wasn't being described within this planning statement is that you won't find in the narrative or the plans or anywhere else reference to the creation of what look on my view of the photo to be at least 13 bays, potentially more as the development continues along the eastern boundary, and what their purpose is. It's simply not described in any way. What you do find in the planning history, starting at page 38, is reference, and it's important, of course, to bear in mind what's being described here. What's being described is the planning history rather than any other kind of regulatory history, and it's looking at, amongst other things, previous permissions. And it says previous permissions predate the website records, so not easily accessible by anyone, certainly not by us. And it's understood they have included some restrictions on the use and the height of the open storage. And this was always one of the curiosities of this case, that here was, as it were, the promoter of the application saying that in the planning history there are actually restrictions, but we think it's a restriction to 5 metres, they say later on, but none of that documentation is produced at any stage. Now, as matters stand, it's very difficult to know whether or not that is a proper criticism of the local planning authority. It's certainly not something that I dwell on today, but it's just an interesting bit of the background in terms of what was and what wasn't investigated in this case. The planning considerations are set out in section 6 of the planning statement, and they deal simply with the principle of development, no reference there to what might be an intensification or otherwise of operations on site. It's simply thereafter a reference to design and appearance, residential amenities, and of course the green belt. But reference to the barrier acting as a good screen, and the reason that it's particularly said to be a good screen is because it's going to be at the same height as the open storage that is allowed on the site. And again, just pausing to think about that as a proposition. If that were important in any way in the decision maker's mind, then equally that was capable of being the basis of a condition if it's being said that adjacent to Greenbelt land a significant advantage. There are two advantages to this scheme. One of them is that it's going to be a very good screen of the scrap from the greenbelt, and the reason for that is that the storage is essentially going to be at the same height. Then that by itself, if the officer thought that the height of open storage couldn't be controlled, would provide the basis for consideration of that issue as well in greenbelt terms. Now the decision itself is behind tab 4, and then the objection is behind mini tab 5, starting at page 45. And as we go through the matters here, we have first of all technical matters, and as my lords have read that, you will see that it does criticise, as it were, the level of information that was being provided, the absence of clear block plans, how the site was going to work. In number 6 we have, for example, no indication anywhere within the application of the relationship between this proposal and the approved plan, and it goes on to describe what had been previously approved. The proposal is 5 metre high, concrete fence throughout, but without any reference to how the yard is used or intended to be used. The increase in height will implicitly allow a material intensification. So that was the phrase that was being focused on and put forward there.
So where do you get that from? I mean, it's just stated. The increase in height will implicitly allow. Well, what's the evidential basis for that?
Well, as a matter of how the yard is likely to work, if you're not given the information about how the yard does actually work, and it seems like a very significant amount of money to be spending on the creation of the walls, and you know that historically the site operator has stored materials to the capacity, essentially, of the then enclosures, to the point that they've fallen over. So that has been the way that the site has been operated, in the sense, as well as a neighbour can tell, looking at it without having any formal documents describing the work and how the work might change. Then if that pattern of behaviour is to be continued, then if you have a much more robust, longer, higher method of enclosure with a large number of bays attached to it, then it is a reasonable deduction. We don't say the local authority would necessarily be driven to this. We just say that if they had opened their minds to it, if they thought about it in the way that we say that they were legally required to, that is a conclusion they might well have come to. As my lord knows, for the purposes of law, I don't have to go that far, but I say that's a conclusion that a local planning authority might well have come to in these circumstances. It looks like an attempt. Will it implicitly allow a material intensification of the use? Yes.
Are they talking about the whole site or just the use by the wall?
Well, it will be the whole site.
The whole site.
But
well, why would the wall have any impact upon what's being stored 50 metres away?
Well, because if you can intensify the level of activity, the change in intensity might not be the same across the whole site. But if your operation before has been to store very significant quantities of materials at the enclosures to the site, and then the enclosures, as I say, are made much more robust, much bigger in terms of their dimensions, and there appear to be additional facilities in the form of the bays to allow there to be a more efficient use of that space, then those things together, and bearing in mind it's a business that's being operated from the site, all of those things taken together can lead one to make a reasonable deduction. But part and parcel of this may have been to increase the productivity of the site, increase the efficiency of the site, increase the profit of the site. As I say, I don't say that the local planning authority would necessarily be driven to that conclusion, but they did need to investigate it because the consequences of that kind of change in circumstances where there was evidence before them that there were contaminants leaching is that that problem might well be exacerbated.
My fault, I'm still not quite following. Why is the wall going to materially intensify use when they could materially intensify their use anyway? Assume no wall, why shouldn't they just simply put as much as they possibly can on the site to 5 metres?
But my lord, here the risk is that we do start to get into the realms of complete speculation as to how the site might operate in future. And
No, but
we don't know.
You've got to show that the boundary wall is going to lead to material intensification.
No.
You don't have to?
No. I have to demonstrate that there was material there that an authority discharging its inquisitorial function should have considered investigating. I will respectfully submit, I don't have to demonstrate what the result would be.
Well, this is where we come into Penwith. What is the text? See, in Penwith, it was a known fact that it was inherent in what they're doing, that there would be material intensification. Now, what's the test there? Is it a possibility, a suspicion, balance of probabilities, a certainty? You tell me what the test is under Penwith.
Under Penwith, it was a clear case, as my lord says. It was the promoters.
It was absolutely inherent in the whole.
And they made no bones about it.
So, is it enough that you simply raise a concern? Is that enough?
Well,
I just want to know what the legal test is.
In terms of the legal test is, was there a flaw if the authority said, we do not have legal power?
No, don't go back to that, please. I want to ask you, first of all, what is the test? If you're approaching this under Penwith, is it simply enough for someone to raise a concern, or must it be more than that?
It's enough for us, as an objector to the planning application, to raise a concern.
Raising a concern, that's sufficient.
Right. Raising a concern. And then the authority has to consider it. And depending on...
Right.
Depending on the gravity of the information that the objector is able to provide, the authority may be able to bat it off very easily and say, well, look, I see what you've said in one line by way of mere assertion, but I don't think there's anything in it as a matter of reasoning. My conclusion is there is no risk of there being intensification. And the Evans case does help. The Evans case in our bundle does help with the idea that you don't have to show the authority doesn't have to show in order to impose the condition, because it's of course the authority that is imposing the condition. They don't have to show there would be a material intensification. It's enough to show that there could be.
Could be
in Evans. So, but that is when it moves to them to consider the legal test.
Yeah.
What we say is that we're at an earlier point in the process where they have to consider, as a public authority, the point that we have raised, and they have to do it in a legally proper manner. And where we say they have fallen down is that their apprehension from start to finish in this exercise was that they simply didn't have a legal power to consider this issue. If they had have done, it is not inevitable that they would have reached the same conclusion.
If you're right on that, then there's an error of law.
Yes.
If you're wrong on that, why does that leave your case?
If I'm wrong about that, then that is the central plank of my case.
Because we've got various grounds of appeal, but
yes.
I think they all are variations on a theme, aren't they?
Yes, they are. That I would accept that.
So it does come down to the true interpretation of the planning permission. That's very clear. Yes. Good. Yes.
And I mean that is the top of page 236, is it? You know, in the officer's report.
Well, let me just get that.
Because that's where he's dealing with your complaint
Indeed.
about misunderstanding the history,
Yes.
your complaint about intensification being discounted. I mean, it's that paragraph, isn't it?
Yes, that's the only paragraph in the report that bears on it. So, my lord, if we go back to the objection, I was taking the court through page 46. And the statement was made in paragraph 6, and then paragraph 7, which is, as my lords see, inviting the authority to think about what the justification for the height of storage that is being applied for is. Where is, the letter almost asks rhetorically, the justification for a proposal to increase the boundary enclosure by some 3 metres in height? The application should clarify, we say, exactly what the permitted height is, or if not, then what the intended height of storage is, and how that is enabled by a 3 metre height increase in the wall. And that's an observation that's being made against my clients knowing and saying positively that in fact there has been historically storage over that 5 metre level, so at metres, 6 metres, up to 8 metres. It's on that basis that the inquiry is, well, if it goes up to 5, and if the boundary is more robust, why is it the case that that wouldn't necessarily facilitate storage at even higher levels? When you
But that would be in breach of existing conditions anyway, if paragraph 2.2 of the application is right.
But those conditions, that may be true, but those conditions have never been uncovered in the planning world. So there is no planning condition that has been shown to us that restricts the storage to 5 metres.
There is an environmental permit condition.
There is a permit condition which will be obviously regulated in a different way by a different agency. And what the authorities show at a very high level is the fact that there is an overlap potentially between the two agencies here. That doesn't mean that the local planning authority doesn't have to consider whether to act. On a full consideration, they could say, actually, this is something that we think is better addressed and will be effectively addressed by other agencies. Again, that would potentially be an answer that was open to them, but there's not the beginnings of an inquiry or a conclusion along those lines. There is what in the report I would suggest is a throwaway line on the basis that if there is a problem, it's something another regulator can deal with. But there's no analysis of the problem beyond that extent. And so, yes, as my lord points out, that's one of the curiosities in this case, that here is the applicant saying that there are conditions and that they're planning conditions, because it's in the section that's dealing with the planning history. But none have ever been produced to us. And if they were produced to us, then we could approach the local planning authority and say, well, look, we think there's a case for enforcement here, based on that condition.
In the same way that you've already approached the Environment Agency.
Yes, that's right. But of course, what we don't necessarily know is whether or not the local planning authority would react the same way to it. And the only indication we have on that at this point in time, is that the planning officer appears to have accepted that with hindsight there might have been wisdom in imposing that kind of condition. Now, that doesn't necessarily mean that there would be enforcement, because the test for enforcement will be different from the presence of the condition itself. But that is at least an indicator that if the authority were asked to think about it and they thought they had the power to enforce 5 metres, they might consider it. What I say is that it should not be the working assumption that their approach to enforcement would necessarily be the same as the Environment Agency, as other regulatory agencies, who may have different policies and priorities in place in terms of dealing with contamination and other issues. But going back to the objection, point 7 clearly asks the authority to consider these questions about what the justification is for the level that's being chosen. And point 8 seeks again to make the point about, well, at the moment we don't know how the use is operated or is intended to be. 9 deals with the point about contamination and the soil report. And the judge had some criticism of the sufficiency of the evidence there. And just as I'm going through the documents, if I address that now, you'll have seen our submission in our skeleton about that. What we say is that in terms of, again, an inquisitorial process rather than an adversarial one, we did as much as could reasonably be expected in the circumstances to give the authority evidence that there was a serious issue that required consideration. We did trial pits on our own land. We had them analysed by an expert, and the conclusions in that analysis were clear and were not contradicted by anything that was provided by anyone else. So in those circumstances, they provided a foundation for further investigations. And there was no suggestion that those materials that were leaching across to our property had come from anywhere else. And as we know from the soil report, each of those contaminants was consistent with the use that was going on.
There was a suggestion. There was a suggestion that there was a source of tarmac. But I'm not sure that was necessarily pursued. And there was also this proposition that analyses it tells us what the limits are for development of residential properties. It doesn't say what this is in relation to any other relevant standards.
No, it doesn't. And again, that is something that might be capable of conditioning how the authority would approach the planning application. I accept that. And it might be capable of conditioning how other agencies would approach deciding to use their powers. But at this point in time, our case is, well, we're putting enough, and clearly enough in terms of a planning objection, in front of the authority for them to make the inquiries and bottom the issue out and see if there is a need for further analysis of how the site might be intensified, whether that's in reality part of the intention, even if not actively expressed in the planning application itself. And the point that we make about that is that, again, just testing some of the propositions. If there were very clear evidence that, in fact, as a result of this change, there was going to be a material intensification of the site, then it should not matter for planning purposes what description the planning application is given, what the planning statement says about it. What matters in that respect is what conclusion the local planning authority forms about the likely impacts of the application, the features of the application, because that is what goes to the substance of it, rather than how it might be described by a planning consultant on behalf of the applicant. So 9 deals with contamination, and then there is a section dealing with the relevant chronology, history and observations. And again, in terms of what is being described there in point 1, and this is all supported, as it were, by reference to the photographs taken at various points in time. 1, metal uprights not strong enough to retain the lateral force of the scrap stored on the other side, forces the fence to fall over, the point we discussed. At 5, the overtopping of the boundary or pushing through it. 6, consequent engine parts and metals physically present on the plane.
Yes, well, we've read this document several times.
Then the only other overarching point I would make about it is that in terms of its quality and the level of detail it goes into as an objection, it was sufficient, we say, to raise these issues on the authority's radar for them to be fully considered.
Could I take you, please, to the top of page 5 of this letter of objection, page 49 in the bundle?
Yes.
So the top paragraph. Is that what your clients are seeking to achieve? Firstly, a reduction in the height of the wall from 5 metres down to 2 or 3 metres, and secondly, reducing the height at which scrap can be stored on the site, anywhere on the site, down to the same height of 2 or 3 metres? Is that what this paragraph is suggesting? That's why I read it.
Yes.
So across the whole site, not only should the wall be less than 5 metres, but across the whole site, there should be no storing of scrap above a height of, say, 2 or 3 metres.
That might be the logical conclusion that
that is what this letter is suggesting.
Yes, and if that were a situation that resulted in... We don't share the authority's view about the impact this has on Greenbelt land. We acknowledge that it's for them to form a view about it, and it's very difficult to challenge planning judgment, but that doesn't mean that we agree with their assessment about it. We have our evidence in relation to the issue of contamination. So from our perspective, if the level of operation were to be reduced here in a way that reduces the contamination on the land and reduces what we say are other planning impacts as well, then that would be a benefit as far as my client's concerned.
Well, I can see that, but I'm sorry to nibble away at this point. So even storage of scrap many, many metres away from the boundary, yeah? You say even that may have a contaminating effect?
That would need assessment. The answer is I don't know.
But you can't just say it and then say it needs assessment. I mean, is there some reason basis for thinking that across the entirety of the site, nowhere should you have more than 2 or 3 metres height's worth of scrap? Otherwise, there'll be contamination of the adjoining land. And I can understand it when you're getting close to the boundary, but what I'm still struggling with is why does it need to be across the whole site? Yeah, that's what this letter is saying.
Yes, because if there's a lower level of operation, then one might think that that will, in general terms, produce a lower level of contamination.
Is that contamination coming from storage of scrap many metres away from the boundary?
Well, it would depend. It might depend on weather conditions, for example. It might depend
it might. But I mean, no one's mentioned underground water channels, anything like that. I mean, this is just hurling out possibilities. I mean,
But my lords are asking me, as it were, an argument. I understand why, to entertain possibilities that go beyond.
You're saying it's for the council to
where our case goes. Absolutely.
Yes, ma'am. Yep.
And so, as my lord has pointed out, what that paragraph does do is provide further detail in relation to the excessive lateral forces that were being described. And so, to come back to the overarching point, I say that that is my lords will have seen a large number of letters of objection. That is a detailed one. It addresses material planning considerations, and those were matters that the authority needed to take into account as it went forward. I will not dwell, in light of my lord's indication, too much on the local guidance. My point about the local guidance is...
really what I was saying is, if the local guidance is relevant, speaking myself, I'd like to be shown how and why it's relevant.
Yes. Well, in relation to the local guidance, that's technical guidance for applicants and developers. It starts behind tab 7.
Yep, this one, local guidance, yep.
And within the introduction, as the judge observed, it has as its focus in the introduction the council's aims of bringing derrick band back into use. It refers to various other documents, including Planning Policy Statement 23, and my lords will have seen that the judge set out the relevant sections of PPS 23, which is not limited simply to contamination affecting residential developments or proposed residential developments, nor is CLR 11, the other document that is referred to there. The flowchart that is referred to in paragraph 110 of Appendix 2 is not limited to residential development. What I say the correct construction of this guidance is, insofar as it has a certain emphasis on residential developments, is in paragraph 2.2. And what that paragraph is doing is seeking to impose a heightened bar in relation to proposed residential development. So in any proposal for residential development, those steps will be required to be followed under the local guidance. What it's not doing is taking away the force of any of what follows from other forms of development where plainly box 6 applies, and if one thinks that there's a suspicion of contamination on part of a site, that's enough to activate box 6 and PPS 23, and at that stage there needs to be a proportionate investigation. And of course, what's a proportionate investigation will depend on all the factors that are in play. So this local guidance is not concerned exclusively with residential development. That's what I say about that, and that's also consistent with looking at issues like, for example, under the Phase 1 desktop study site walkover, going towards the foot of page 67, you'll see in that bullet point list a number of potentially relevant issues, and the last of those is an appreciation of all potential receptors on and outside the site. So again, that's looking at a broader area.
Sorry, where are you reading from?
Sorry, it's paragraph 2.8, my lord, which starts on page 67
Yeah.
towards the foot of that page,
Yeah.
and a list of bullet points, last bullet point.
Yeah.
The object of the study, formulate a conceptual model, and one of the things it ought to do is provide an appreciation of all potential receptors on and outside the site. And then one does what is a relatively conventional analysis in terms of contamination. You look to find the sources, pathways and receptors, and of course, that part of our soil investigation adopted that approach as well.
It's not entirely obvious that this particular guidance was focusing on the position of a boundary wall.
No, because it will depend on what the consequences of
But
changing.
your point is it isn't confined exclusively to residential development.
Exactly.
That's your point.
Exactly, and nor is the national guidance,
Yeah.
as is clear from the passages that appear behind the next tab, pages 82 and following. And so we see this is the PPG guidance published under the MPPF, as it were. This is the part of the 2014 edition, but not all of the guidance is updated. And land affected by contamination, so it's as broad as that. Why should authorities be concerned? And then it identifies the risk, including the risk to property and the wider environment. It could also limit or preclude new development. So those are the kinds of risks that are expressly averted to in national guidance. And then the next two paragraphs deal with, is it just a planning matter, or what is planning's contribution? And then we see reference to Part 2A, and my lords have the guidance for Part 2A and may well be familiar with it. For the purposes of considering our case, I would just invite you, when you look at this, to consider Section 1, the objectives of the Part 2A regime on page 95 and following, and the introduction, just to give a reminder, as it were, as to how different the standards and approach can be under Part 2A compared to the planning code taken as a whole. And again, just as a matter, as it were, of interest, the consistency of national guidance with local guidance, if my lord looks at page 83, back in the PPG, paragraph 33004, the second paragraph there, starting only a specific investigation. My lord sees that. This ties in with what the local guidance says about residential developments, just highlighting the relative sensitivity of proposals that involve housing with gardens, schools and nurseries and so on. So that's consistent with what the local guidance appears to require in terms of a heightened standard for certain proposed forms of development.
Your point is not that the work itself in building the boundary wall would have a contamination impact.
Yes. Indeed.
It's again coming back to that it would be increased use, increased risk of contamination. Is that it?
Yes, absolutely.
So what investigations needed to be undertaken?
What could have been done along the lines of the objection letter would have been for the authority to arm itself with how the applicant was proposing to use the land, what the justification for the 5 metres was, in particular on a site where there did appear to be storage to 6 to 8 metres. the authority ought to, if
So
we're...
it's the same points as with...
Yes,
your point
it's very,
about
very similar,
intensification.
but if we're onto a sort of, as it were, our wish list of what the authority ought to have investigated before it could reach a robust decision in relation to this matter, then what we say they ought to have done is, for example, established accurately at the time of making this decision whether in fact there was a condition limiting the height to 5 metres. If not...
You're saying they shouldn't have made a decision at all, they should have adjourned the matter for further investigation?
Yes.
Or impose a condition, or grant it subject to a condition.
Yeah, if they again, because we're in this awkward position where our case is they don't have power to consider it, and certainly they don't seem to have considered it at any length. It's difficult for me to say what their ultimate conclusion should have been. But yes, it should have been one of those two things. They should have gone away.
It's quite difficult to formulate a condition. So maybe just adjourning the matter might have been.
Yes, in order to arm themselves
for further investigation.
Yes.
I mean, not make the decision they did make.
Exactly.
That's your point.
Exactly.
All right. Anything else on this document?
Well, just the reference on page 85, middle paragraph, the largest paragraph there, starting, if there's reason to believe contamination could be an issue. So that's, my lord was asking me about triggers and thresholds. Proportionate but sufficient site investigation information to determine presence, nature and extent, risks it may pose, and to whom. So those are the kinds of steps that we would have expected an authority that thought that this was within its powers to have thought about. And the next two paragraphs provide further guidance in relation to that, and indeed in relation to compliance with box 6. So to give a more direct answer to the question my lord just asked me about deferring matter, yes, they would have needed to defer because they didn't even have the level of information that box 6 requires them to have. So if they were, as it were, fully discharging their duties, then that's the approach we say ought to have been taken. And so then to the report.
Yes. Do we need anything from? Is there anything in tab 9 we need to look at?
Well, I did give some very brief references.
Yeah, I said need look at. Do we?
Now.
No. Right. And then at tab 10 we have the
Yes, that's for
planning
unit
application.
10.
Yeah.
And on the plan at page 161, you can see the connection between units 10 and 16. The dog leg was referred to.
My lord, just to be clear, tab 10 was the 2010 planning application, not the...
Yes, it was. Yes, it was.
Forgive me.
And then we have the environmental permit at tab.
Sorry, I was just going to say at page 163 of that, it's the interrelationship between the Environment Agency and the council. You do see, my copy, someone's put it in yellow, but there was a limitation of 5,000 tonnes per annum.
Yes.
Is that right?
Yes.
And that still remains?
That certainly remains in relation to...
I'm getting nods from behind you, but you
unit
may
10
know better. But, yeah. Okay,
I'm
thank you.
content to accept the nod. Great.
And then we have the environmental permit
Yes.
at 11. Now, I just want to be clear, there seem to be two permits in here, and I'm not quite clear which one one's meant to be looking at. We have one at 176, yeah?
Yes.
And then we have another one at 20, correction, I got this wrong, 202. There's 2003 and there's 1998. So could you just help me on what's the interrelation between the two?
In relation to my understanding is that what we have at 202 is the, as it were, earlier
Yes.
permit in time, which deals with the working plan documents that are attached to it, and which you can see at pages 227 and 228 onwards.
Well, it's just that taking 202, which is the 26th of March 1998,
Yes.
we find at page 206 in the schedule, 6.9, that's where no waste material should be stored or stacked to a height greater than 5 metres. That's where we find it.
Yes.
But what I haven't quite worked out is what's the 2003 environmental permit?
No. Well, my understanding is that in relation to the 2003, what's happening there is a variation of what had gone before, to the extent that is being described in that notice of variation.
But where does one find the 5 metres in that one?
I'll be corrected, I'm not sure it's present.
Well, that was why I asked. I
Yes.
couldn't find it in that
No.
one. But does everyone agree that the 1998 environmental permit still has a life of its own?
Well, one of the points that I made in my skeleton argument in terms of whether or not the planning authority needed to consider this is that it's not clear to us as a bystander for these purposes the extent to which the Environment Agency might say that they are still entitled to rely on that restriction on what appears to have been a quite complex site over time. We don't have anything to indicate that they positively can't, but we don't have a view from them, the authority don't have a view from them, that they can.
Is one of the permits limited? If you go to page 201, there appears to be a larger part of the recycling site and then a smaller part for the licensed area. I just wondered whether that was the answer to the point. But you've had these for years and I haven't.
My Lord, I don't think maybe it'll be help, but otherwise I would need to take instructions.
Well, look, just to give our position, if you look at page 173.
173.
Yes, so you'll see there that we've got on the left the notice of variation with the introductory note, and then in the table under the introductory note, you'll see status log of the permit, and you'll see originally the license was issued in 98. They were called licenses then. Then you have a license modified in 2004. Then we've got an application which this arises from, as it were, the variation, the application to vary, which was duly made, and then the variations determined in 2017. So that gives the summary or the chronology, if you like, of the life, if I can put it that way, of the
But
license.
what's the document then at 176?
At 176.
Dated 21st of May 2003.
2003. Well, I think this would be forming. This would form presumably part of the permit and license when read as a whole, as modified presumably in 2004. So that was our understanding of what's happening at 176, and that they're all still in force.
Yep.
Yeah.
Well, Lord, I was going to turn next to the decision itself, and that's behind tab 13.
Well, it's officer's report,
Yes,
by reference to which the decision was made.
indeed.
Yeah.
And we see two policies being identified, and then consultation responses are discussed at the foot of page 234. And there is an attempt, as it were, to summarise the general thrust of the objection in the penultimate paragraph on that page. And the point I make about the way the consultation was summarised, the consultation responses were summarised, and indeed the report as a whole, is that there is just simply no reference to the idea of intensification as a planning concept through this report.
What do you say about the statement at the foot of page 234?
The first sentence,
Comments on consultation responses.
yes,
What do you say about that?
but the running of the scrap business is not a matter for consideration in the context of the application. That was wrong. It was, to an extent, a matter for consideration. There was no suggestion by us, and of course there could not be, that the lawful use could not, should not continue. But this is an observation made, having read our objection, which refers very clearly to the idea of intensification. And so when this sentence appears here, what the officer is saying on a fair reading of this report is that those elements that are direct points about the running of the business are no part of the consideration of the context of this application. And that is consistent with the absence of any reference to intensification as a planning concept
Well, you say the
in
absence.
this
Well,
report.
we'll come on to that. You say they had to use the word intensification.
No, but
Well, what about the sentence at the top of page 236? That's a reference to intensification just by using, but avoiding technical language and using plain English for councillors.
well, this was a delegated report, but on the basis of what's written there, there is a clear difference between recognising that a planning harm might arise and recognising the idea that intensification may give you a lawful basis, a lawful hook on which to hang an additional planning condition.
I know you're going to come on to that, but the first sentence at the top of page 236 is surely, in ordinary language, a reference to intensification.
My lord, I don't. No,
No?
I don't
No.
accept that.
Right.
Intensification has a specific idea in planning law, and it is that when you change the level of activity at a site to a certain degree, that may give you the basis for imposing a condition.
I understand that point, but are you saying it's fatally flawed because the word intensification is not used?
No, I'm saying read as a whole, this report is fatally flawed. And when you read it as a whole, you have that part, the part that my lord was just discussing with me about the running of the business, and the statement that there is no planning mechanism for dealing with this issue. So it's reading all of those
that
things
point
together.
I understand, yes. All right, anyway, so coming back, so we have the statement, you don't agree with what's said at the foot of page 234, and then that's over the page is qualified by saying, if the business causing environmental pollution, the enjoined owner could report this to the Environment Agency.
Yes, and so just to finish the point on 234, we know what the officer was interested in, and the report's entirely consistent on this throughout. The report identifies there two issues for consideration, and those are the only two issues that the officer thought could properly be addressed within this application. And then we have, at the top of 235, where if business is causing environmental pollution, the adjoining landowner could report this to the Environment Agency. I say that is consistent, that line is consistent with the idea that the planning officer thinks that there is no planning power to address this issue. So if it is going to be addressed in the absence of any planning power, the only way that the objector can make that happen is through the Environment Agency. So that's the basis upon which that paragraph is written. It's not written on the basis that here is an evaluation of whether or not this is the kind of situation where it would be better for the local planning authority to take a particular step, or whether it's appropriate for the local planning authority to take a particular step, because the officer has concluded that it's simply not something the local planning authority can do.
Is it not consistent with the officer thinking they've raised this issue, I'm not going to determine it because I don't need to, because the Environment Agency is around and can deal with it if it's valid? And I mean, you're quite right, you can impose an additional condition. I've never thought it a good idea because you lead to confusion. And this officer may have taken the same approach.
If that sentence stood alone, then I would agree with my lord that it's consistent with adopting that approach. What I say is that that sentence actually appears after the officer has already said, well, the running of the business is simply not a matter for me, and also appears in exactly the same report that contains the text at 236, which again is consistent with the idea that there is no planning mechanism to address this. So when you read all of those three things as a whole, I say, no, that's not what this statement was designed to do. And there is no evaluation of whether or not there being two regulatory agencies that might intervene. In fact, it would be better or more appropriate for it to be the Environment Agency.
It's a general principle of planning law, as I understand it, that if a condition is to be attached to a planning consent, it needs to be necessary.
Yes.
Right. Now, in that context, isn't it legitimate for a planning officer to take the view, well, if pollution is concerned, there is always the Environment Agency available. Therefore, it is not necessary to attach a planning. Is that not a legitimate approach?
It's entirely legitimate for them to take that factor into account. That's what the early authorities in the authorities bundle show. I accept that. What the authorities equally show is that there is no legal obligation on the local planning authority to leave the matter to the Environment Agency.
I understand that, but they're entitled to take it into account in deciding whether a condition is necessary.
Yes, absolutely.
Right. Yeah.
My lord has my point about reading the report as a whole, and this feature, as it were, doesn't come back any later on to be discussed or evaluated in any greater level of detail when the report does turn to the issue of conditions. And so, in terms of the evaluation of the proposal which follows, and it's important perhaps to note the order of events here. Next on the evaluation of the proposal, main issues, no mention in terms of identifying the main issues of the intensification issue. And the two main issues are then set out under their separate subheadings, visual impact, and the point about what my lord has said might be, as it were, a reference to intensification by any other language at the top of page 236 occurs in the context of a discussion about visual impact. It's not occurring in the context of a discussion about whether or not the authority has power to impose a condition relating to contamination. And in terms of what the authority...
The first sentence is referring to the suggestion that might worsen the existing problems of scrap and pollutants escaping the site onto his land.
Yes.
That's nothing to do with visual impact.
Well, it's being brought under the umbrella of the visual impact considerations. I appreciate it, and I agree, it's a separate paragraph attempting to identify in a very summary fashion part of the objection and only part of the objection. But it's, in terms of reading the report as a whole, it is fair to observe that there is no separate subheading in this report that deals with the issue of contamination or the risk of contamination, which was a main plank on any view of the objection that was being put forward. And the reason for that is easy to understand in terms of reading the report, if it's accepted that the various references that I've given lead one on a fair reading of this report to the conclusion that the officer thought this was outside of his powers. There was no point dwelling on it because it simply wasn't something that could be usefully addressed within a determination of the application. And on that point, I say again, it is helpful as far as the claimant is concerned of what the authority might have done if it had taken a different view about the extent of its powers, to note there the references to the idea that it might have been prudent to impose a condition with the benefit of hindsight. Simple fact is, there's no planning mechanism to prevent the operator of the site storing scrap to the height he wishes, regardless of whether this application is approved. So in the officer's mind, there hasn't been in the past, and there could not now be under this application.
The relevant condition being imposed by the Environment Agency on the licence, the 5 metre licence.
But that's not the way that this, I mean, this report doesn't refer to the licence at all, or the limitations contained within that licence. There's no indication, I don't think, that the decision maker had that licence or had analysed that licence at the stage of writing this report. But what this implicitly does recognise is the idea that there might have been a benefit in having a planning mechanism, not a regulatory mechanism that might be enforced by some other body, depending on their own decision-making processes. But there might well have been a benefit in having a planning condition that expressly dealt with this issue. But there was no mechanism available. And I say, if one reads those words, an important part of the report, because it's the only part of the report that deals with this issue about scrap and pollutants, then one is left, I say, inescapably with the conclusion that the officer thought that this was outside of the local authority's powers. And that's...
Had a contrary conclusion been reached, one can pretty easily foresee the judicial review claim that Benfleet would have brought. They would have said you're simply using this boundary wall as a peg to get back in, a planning condition you forgot to include back in 1998.
But if
It'd be pretty easy to see how they would run it.
Well,
anyway, there it is.
Well, they might make that criticism, but if it was a legitimate exercise of
No, I
judgment,
understand where you're coming from, Mr. Bigland, but one can foresee how Benfleet would have reacted. And I think what you're really saying is they should have gone away and thought harder.
Yes.
And so you're really saying.
Indeed.
Yeah.
And on the basis that contamination,
It's a sensitive matter.
It is a sensitive matter. It's a serious issue. It would be in any circumstances. It becomes more so when the local planning authority concerned, if it thinks about the policy side of things, which it ought to be doing in determining applications like this, knows that this is land that might well be coming forward for development under its own proposed planning policies.
Yep.
And so, my lord, in terms of the documents, the only thing left to do is just remind my lords of the photographs that were taken.
Well, hang on a moment. What do you say about the last paragraph at, of page 236?
That is a standard paragraph that will appear in most officers' reports.
Well, it's not standard because he's referred particularly to those raised in the letter from Smart Planning dated 30th October 2018.
It's standard in that it refers to the one main objection that was made in this case. It doesn't provide any further reasoning. It is in a standardised form in terms of the use of language. And what it doesn't indicate is anything that is capable of overcoming the difficulties that appear earlier in this report. This is not a case, I would submit, where we have to draw inferences from collections in the text, various different passages in the text, to come to an ultimate conclusion about how the local authority approached its powers. Here the officer tells us, and I say tells us in terms, so there's no need to cast around for where inference might be made. It just happens, and this is unsurprising, that the way that the report deals with things is consistent as a whole with the idea there's no planning mechanism to address the contamination point here. All of the rest of the report is entirely consistent with the meaning that I ascribe to that phrase.
Yep.
And so, my lord, just for the court's reference again, the photographs taken at 2018 appear at pages 248 and following over the few pages there, just as some indication. Again, the photos are not of the highest quality, but they do give an indication of the nature of the difficulty that was arising at the site.
We're taking 249. I'm afraid the photograph is very poor quality, with all respect. But,
Yes.
is it being suggested that was more than 5 metres in height?
In relation to those photographs, there's no specific measurement there, but there are measurements on some of the later photographs. My lord, just give me a moment. So, for example, if we go to the later photographs, I appreciate that these are from January 2019, but if my lord wants to see the issue, we can see it at pages 339 and following in terms of material that was generated at that point in time. And just with the observation that if this matter were returned to the authority to consider, then obviously they'd have to look at this kind of material and observe that there are, even with the presence of the new enclosure there, continuing difficulties in terms of the height of the storage of scrap.
Sorry, that's page 251 and 250, is it? That you...
No, sorry, my lord. Right towards the back of the bundle, behind tab 10.339, there are some later photos taken in 2019. So one can see here the extent of the enclosure. We can see some levels of overtopping which do have measurements on them in some of the photos. See 340 and 341.
At the bottom of 341 is very difficult to see, isn't it?
Yes.
342 is a bit better here.
Compared to 344, for example.
But it's the same person who took the photographs at 251 because the boundary has the same spelling.
I think that's right. Yes, ma'am. And so one sees, as it were, a continuing issue, which if the matter did go back to the authority, plainly they would have to take into account along with all the other material planning considerations.
But no photographs of this kind were submitted to the council in 2018.
The 2018 photos were before the council,
But the measured off ones of the kind we've seen.
So, can I then turn just to a few of the authorities? So if we start with tab 1, the Penwith case, my lords will have seen that that involved the imposition of 3 potential conditions relating to the substantial extension of factory premises, where the purpose of the extension was to essentially facilitate 24-hour working within the existing buildings. And so conditions were sought to be imposed in relation to working hours, levels of noise emission, and indeed in relation to a scheme dealing with the addressing of emissions from the site. And then the point that was taken in that case was whether or not those conditions were outside the powers of the authority. And it was a challenge that was successful, and as we know from the skeletons, in fact, by the time that the case was before the court, it was common ground between the parties that there was a legal power to impose a condition in circumstances of intensification. And the question for the court became whether or not, in those circumstances, the authority could reach a proper conclusion about whether or not there was a sufficient connection between the condition and the planning mischief that it was seeking to address. And in relation to the two main conditions, it was accepted that that was a conclusion that was open to the authority. So, of course, as my lord pointed out earlier, the evidence in that case was clear in terms of what was being sought to be achieved. But I say that that doesn't stop the principle applying, and the principle is common ground between us. As I understand it, my learned friend distinguishes Penwith on its facts, but I say that if the investigations that we suggest ought to have been carried out on a proper basis, the authority having accepted they could reach conclusions about this matter, then they might well have come to a decision along the lines of Penwith that there was a sufficient connection here that would entitle them to impose a condition relating to the height of open storage. And so the principle was capable of applying in our circumstances.
On the requirement of it must relate to the condition must relate to the development being permitted. Here, the development being permitted is the wall, the boundary wall.
Yes.
I'm still slightly troubled by. I can understand the point if it was that will mean scrap will be stored right up against the wall over it, but I can understand that, but I'm still troubled by your notion that it extends to the whole site. How does that relate to the boundary wall?
I don't need. We're saying that that may be the case, but we don't need to go that far in order for the condition to be capable of being enforceable. If there was a suggestion that levels of storage above 5 metres meant that there was the potential for more material on this site, for it to be processed more efficiently, for that to use part of the storage and bays that are now very close to my client's land, then on that basis it would be open to an authority to conclude that there's a sufficient connection between those things.
And if the storage was less than 5 metres against the wall?
Well, it would be. This is a matter for the authority to determine.
Isn't it a reasonable presumption that people are expected to comply with the law? And here, the environmental permit does not permit them either to store more than 5,000 tonnes on the site at any one time, or to exceed 5 metres.
Yeah,
so why shouldn't the council take it that, by and large, this operator will comply with its legal obligations?
Because they were being told by the objector that that wasn't the position. The objector was saying in the objection, we now have better photographic evidence, but the objector was saying in terms in the objection, scrap is being stored to heights of 6 to 8 metres on occasion, and I'm the neighbour, I'm next door. So
and so the council should do the job of the Environment Agency. Is that what you're saying?
No, I'm saying that I'm saying that here the council recognised that there was a potential merit in having this kind of condition, presumably so that they might choose to enforce it. And one can see why, because it goes directly, potentially, to issues of planning harm.
I mean, the difficulty with your very broad proposition is this, that in almost every contested planning application, the objectors will say matters which may be strongly contested by the applicants, and there is a limit to what the council can properly investigate. I mean, they have limited resources and all the rest of it. And if something is clearly covered by an existing condition governed by another agency, what's wrong with saying, well, you know, it's a matter, which is what they really say at the top of the report, it's a matter for the Environment Agency.
Well, if that had been done on, as it were, a proper and full understanding of the extent of their powers, if the authority had expressed in the report, not that there's no planning mechanism, actually we think there is a planning mechanism that might allow us to address this, But we've also seen an environmental permit, and we're told that the restrictions in that are still lawful and continue to bind, and we think that's right, we agree. Then we also have thought about, bearing in mind that the Environment Agency haven't pursued any prosecutions up until now, we thought about that, or haven't pursued any action up until now, but we still think on a balance of judgments that nevertheless it's not one of those cases where it would be appropriate for us to impose a condition. If those kinds of things have been taken into account, then I would struggle because I'd be facing a rationality challenge in those circumstances. But what hasn't happened here, and the baseline of our case, is that those kinds of things simply haven't been grappled with by this authority.
Well, you've made that point many times,
Yeah.
but can I put this question to you, please? If it were the case, I appreciate all questions from judges on the word if are not always easy to answer, but if it were the case that throughout Benfleet Scrap had always faithfully complied with the environment permit, had never had more than 5,000 tonnes of scrap on the site at any one time, had never allowed anywhere on the site it to exceed 5 metres in height, could you, on planning grounds, raise any objection to this permission for the wall?
That might be a more difficult case. But
And what's the answer, please?
Yes, the answer is yes.
You still could?
Yes.
Even if they'd faithfully complied with their environmental?
Even if they had,
Yep, fine.
I can see in those circumstances, as I suggested earlier, there may be some objections that might be made where the authority, because it only has to conduct proportionate inquiries to employ the phrase in the MPPF, could bat away that sort of objection really quite easily and say, well, we don't need to look too far into this because this is a situation where, in fact, the landowner does appear to have done everything in a regular fashion insofar as they were asked to by another regulatory agency. So the strength of our case might be very different.
But you're saying
But that doesn't
you're saying that even where an environmental permit is fully complied with, and even where no original planning permission imposed any planning restrictions, still at this stage, in considering the wall, the council could then impose conditions? As a matter of law, it legally could?
Not that it could necessarily impose a condition. It would need to think about all of those things. And the point
Because you see, what might then be said is that this is using planning as for a collateral purpose. In other words, to make up for the deficiencies of the environmental agency. And that's another Pick's granite point you have to worry about here, don't you?
But if that is happening, if part of the approach of the regulatory agencies means that for resourcing issues or prioritisation issues, that they, as it were, will not get around to this because it's a long way down their list, then that is a factor that the local planning authority could legitimately bear in mind where there is an overlap relating to controls. And just to pick up my Lord's example again, that the fact that someone has historically kept within all of the requirements of their permit would make my case much weaker. But it wouldn't stop me, for example, as a matter of just postulating an example, saying, well, actually, we suspect that if these boundaries are fortified, made much longer and made much more efficient, that for the first time, there is a very real risk, and we think the probability that in fact there will be a breach. If we were to be able to produce evidence suggesting that that was a likelihood. But that's a very different case. It returns to what I say is the same thing, which is that it was for the authority to analyse all of these on a proportionate basis, and of course they have resource limitations. But box 6 is there for a reason, and again that sets a baseline with which every authority should be complying and every applicant should be complying.
Coming back to Penrith,
Yes.
And is this Douglas Frank? I can't remember. It's Douglas Frank, yes. And the reasoning seems to be very much predicated when he was deciding whether or not it related to the development being permitted. At the foot of page 273 of the report, on the evidence, it cannot, my judgment, possibly the condition is not related to the development being permitted, because it is the development that's being permitted which will enable that machinery to be operated.
Yes.
So again, he's stressing it will do it. Yes.
So in that case, there was the factual matrix, as it were, was very clear.
Yes,
and so the judge had no perhaps real reservations about coming to that conclusion. So what this case presents is a very clear illustration of how the doctrine can be applied to the facts. But to compare the wall to the building of the factory, the fact that 4 walls might be put up and a roof in order to enable another building to exist on the site in Penwith was not what was going to cause the planning mischief. It's the fact that having that physical structure present enabled various activities to take place within it, which in turn led to the impacts. And so in principle, this is no different. We're just dealing with an outside area rather than one that is wholly contained within a building. But it's not just the physical presence of that structure. It's the impacts in planning terms that it allows to take place and whether or not they've been properly investigated.
So you say that a potential condition restricting existing use, shall we say, not, just for example, not have storage more than 3 metres high anywhere on the site. You say that can be said fairly to relate to the wall, the building of the wall, boundary wall.
I say, and I appreciate my Lord is concerned that I might be obfuscating, I'm trying not to. I'm saying that at the moment, if the authority fully investigated that question, it would be potentially open to them as a conclusion to say, actually, this wall needs to be lower than 5 metres. They might say it could be higher and it wouldn't create a difficulty. But that has to be a judgment for them based on all of the material that they should assemble relating to the work that is capable of taking place on the site and how intensive it would be if the wall were to be 3 metres or 5, to take my Lord's example.
But in the real world, it makes no sense to have a lower wall now if the storage height can still be 5 metres. And the reason why the wall is 5 metres makes every kind of sense.
But that presupposes the absence of a power in the local authority to condition a lower level of open storage.
Yes, so I mean, it's pretty clear from your letter of objection that what you want is a lower wall and a lower storage height across the site.
Well, we certainly think the authority ought to entertain that as part of their consideration. Yeah. And whether or not they agree with us, right, judgment for them.
Is there anything else on Penwith anyway? Right.
Well, no, not on Penwith.
But I mean, Penwith's obviously an important authority view. You say that sets the principle which the planning officer, you say, did not take into account. I mean, that's your argument, isn't it?
Exactly. The other cases deal with 2 and 3, perhaps particularly some of the overlap that does tend to occur between the functions of other regulatory agencies and the local planning.
Well, I just noticed that just taking tab 2, the Gateshead case, the second authority.
Yes.
I just noted that in that context, as clinical waste,
yes,
page 44, the lined passage, the court was in effect directing itself to the extent to which discharge program will necessary or probably.
Indeed.
It doesn't seem to be thinking in terms of possibilities or suspicions. It seems to be setting a rather higher standard for the purposes of that case.
Yes, But then these are, by and large, cases, and this case is an example, where the investigatory, as it were, part of the function has been completed. So the authority has had the opportunity, taken the opportunity to arm itself with a proportionate level of information. Sometimes that may not answer the question.
Yeah.
And if that doesn't answer the question, then it's up to the authority to draw proper inferences and make proper deductions. And again, we could only criticise that kind of approach based on rationality tests. But that is significantly farther down the line than we say the authority got in this case.
Yep. Right, any other authority then which needs to be drawn to our attention? Speak for myself, I have not been through all the authorities in the bundle. I have considered Penrith closely, as I'm sure my lords have too, but I've not been through all of them. Some of them struck me as being thumpingly irrelevant, to be honest. But so just, would you draw our attention, Mr. Biggin, to the ones that matter?
Can I then just go perhaps to Harrison?
Harrison, certainly.
Abate. And that was a case involving...
So page number, we haven't got...
Oh, I'm sorry, page 98.
Page 98, thank you. Yep.
And so we can take what I need from the head note there. That was a change of use from simply agricultural use to processing animal products which have been introduced as a new use on the site. And if we look at what was held by the court in that case, it was against the old guidance in PPS 23 and the paragraph that indeed the judge below looked at. Last sentence on that page: could not be right that paragraph of the guidance simply said the planning system had to assume that no pollution issues would arise. See Hopkins, which is earlier on in our bundle. The planning decision maker was entitled to reach his own conclusions as to the impact of a proposed development on amenity and whether the site under consideration was an appropriate location for the proposed development. The fact that the impact might be capable of being regulated under a pollution control regime did not necessarily mean the only possible option was for an inspector to leave everything to that regime. If the planning decision maker considered there might be adverse consequences because of the effects of the proposed development on amenity and or issues again relating to the appropriate location, they were entitled to regard such matters as material consideration. So, simple point that arises from that, reflected in the other cases as well, is that it is clear, we say, that had the officer considered these issues, then it was open to him to take them into account as material planning considerations, which may have been persuasive in the determination of this application.
Yeah, and that just then comes back to how you read the report.
Indeed, yeah. Yes. And the discussion is helpful in that case. It's the sidelined passages at page 105, 106. And just going back to a point about the approach of national guidance and it not being restricted to residential type developments, it's just worth bearing in mind the first sentence of paragraph 22 as well, which makes the point that the kind of development that was under discussion here is precisely the sort of thing that was captured by the existing national guidance in PPS 23. In terms of Evans, which is, I'm conscious, a very long case in judgment, but that is where the slightly lower threshold of whether or not there could be intensification arises, and the references in that case, if we look at where the judgment starts, page 100.
Which authority?
This is the Evans Authority, Basingstoke and Dean.
Page
118.
118.
Thank you very much, sorry. Thank you very much.
And that was to do with activity relating to the sorting, washing, packaging of vegetables and salads that was being intensified. and we can see the terms of the planning permission and the condition that was imposed. And in terms of the reason for the condition that was being imposed, it was to prevent a material intensification. So that was considered to be enough in terms of the judgment of the local planning authority there. And the discussion as takes place further in the report at paragraph 111, we have the principle being set out about intensification, which again doesn't appear to have been controversial, as it were, in that case, the ability of the local planning authority to take it into account, but to take it into account on the basis that there was a risk of intensification. And the judge describes at paragraph 123 some limits to the approach there, and in terms of the actual result of the case and why the claimant lost, that's dealt with at paragraph 140.
You might also say that's the language of possibility.
Indeed. And so in terms of what is enough to activate the local authority, I rely on three things in this case. First of all, the standard presence of box 6 and what that requires. Secondly, the detailed nature of the objections that were made on this issue about contamination and the absence of any clear evidence displacing either the facts that were set out or the inferences that have been drawn from them. And thirdly, that insofar as one can ascertain it from the report, the officer equally doesn't appear to have disputed the propositions that we were putting forward in relation to intensification and or the risk of intensification. That issue was addressed in a wholly different way, without evaluation, for the reasons that I earlier submitted. Well, there.
Of course.
Well, I've just been asked to point out in relation to some of the photos we were looking at earlier, in fact there are some photos that deal relatively clearly with the leaching across the property boundary, and you can see them at 3/4.
The puddling, yeah.
I'm grateful.
Are there any other any authorities bundles? Any other authorities you would think we should? Some of the authorities just very conveniently encapsulate the principles, and
yes,
probably don't need to take us through them in further discuss. But is there any other particular authority which bears directly upon the issue arising in this case?
My lord, no.
Well, of course, you'll have the right to reply when Mr. Thank you very much, Mr. Spegler. Right, Mr. Dingemans.
Thank you, my lords. I see that clock's fast. I think it's about 10 to 1, isn't it? So it probably is sensible. I was planning to begin just with some legal principles with which your lordships are probably very familiar, but are possibly still useful just to cover in brief, taking them quickly. And I could probably get through those in 10 minutes. Would that be a sensible approach?
You better crack on then, hadn't you?
Sorry?
You better crack on then, hadn't you?
Well, and then obviously after lunch, presumably, we can pick up the detail of my submissions.
Yes.
I'm grateful. So, my Lord, sticking with the authorities bundle, your Lordships will see that I've referred in my skeleton argument to not very many authorities. There aren't, we say anyway, novel principles in play here, but there are, of course, important, as it were, underlying or underpinning principles which must be borne in mind. So, I don't, as I say, intend to dwell on these, but taking them reasonably quickly, if your Lordships have my skeleton argument, we're at, first of all, at paragraph 33 and 34 in particular. Now, this is the Mid-Counties case in which Mr Justice Hickinbottom, as he then was, set out the useful, sets out in summary the principles to apply to a judicial review challenge such as this, and in particular in relation to the key issues which your Lordships have identified already this morning of how to read an officer report and what it should contain in order to be lawful and reasonable, firstly, and secondly, this important crucial issue of material considerations, which and how one deals with those in the context of the statutory test. So, my Lords, then first of all, please, if we just go to the case, in the authorities we rely on seem to relate to the Forest of Dean. This was the facts of the case are not strictly relevant, but we're at page 307, where at paragraph 5 of the judgment to Mid-Counties Cooperative. The judge there sets out the principles, and your Lordships will have seen from my skeleton that I've highlighted the principles from Roman numerals, Latin numerals 2, and I mean, we don't need to necessarily read through them, but obviously for your Lordships' note, this is, we say, the key frame, as it were, within which both the report and the decision-making exercise should be viewed. Reports, as my learned friend actually referred already to, or acknowledged already, they must be read in the round, in the whole. They must be read as a whole. They are, in particular in our case, reports must be seen in their context as being addressed to a knowledgeable readership. Now, Mr Justice Hickinbottom's comments in this case were directed at the situation that, my Lord, you referred to of a committee. This wasn't a committee decision, this was a delegated decision. And so what the officer was doing, the expert case officer, was setting out his reasoning, addressing it to his, effectively his line manager or the development control manager, who then considered the report, and then the authority reached the decision, which is then reflected in the decision notice. So, as I've said in the skeleton argument, this applies even more in the context of our decision that we're looking at these principles, that what we're dealing with here is knowledgeable or expert readership. The assessment of, looking down at Roman numeral 3 on page 308, the assessment of how much information and what information should go into a report is itself a matter for officers exercising their expert judgment. And we'll come to this after lunch in the detail of the report. But of course, what goes in to the report and how it is expressed and so on is a matter of expert judgment, and in particular in that context, or bearing in mind that context which I've already outlined, of an expert or a planning officer communicating to an expert, another expert, as we have in this case. Then we have further down the list, if you like, there's 4 and 5 and 6, all of which deal with the test to apply to planning applications, which your Lordships are no doubt familiar with, that applications must be determined in accordance with the development plan unless material considerations indicate otherwise. And at 6, we see that one of the critical or key material considerations will be national policy, including the MPPF. 7 and 8 are not so relevant for present purposes, but 9, of course, is very important. Yes. 9 here is set out, again, summarising Lord Hoffman's speech in the Tesco Stores case from 1995, famous House of Lords case, summarising here the principle to apply to material considerations and the fundamental distinction which is echoed in the Baroness Cumberledge case, to give a more recent example of this principle in action. We can go briefly to that. But the basic distinction here between capable of being a material consideration being a matter of law, and then the application or rather the consideration of a material consideration that is capable of being a material consideration, and the application of that into the decision-making process in any given case being a matter of planning judgment for the decision-maker.
Is there any particular bit of the Cumberland case you want us to look at?
Yes, please, my lord. So the Cumberland case was, this is the first instance judgment of Mr. Howe, John Howe QC, sitting as a deputy judge.
I thought it had gone up to the Court of Appeal. No, it didn't go to the Court of Appeal, the Cumberland case?
No, sorry, the case did, yes.
Yes,
absolutely. DLA delivery it was.
Yes, I thought
Yes,
so, but we don't need the court. We don't.
Well, only to note, which I do in the skeleton, that it was approved in the Court of Appeal. So footnote 19 on page 9 of the skeleton just notes that these principles were approved by Lord Justice Lindblom in the Court of Appeal.
So which bit of Mr. Howell's judgment do you want to?
So yes, Mr. Howell's judgment, which is a long one, but again, the fact's not strictly relevant for our purposes here. And this was dealing with residential development in the Forest Green district. But page 344 of the bundle, paragraph 51, is where the judge there considers the test for determining when a decision may be invalid when a consideration that is capable of being material is not taken into account. In paragraph 51, we get again the distinction drawn that there are 2 questions to consider in terms of material considerations. First is whether a specific consideration is one capable in law of being relevant, and the second is whether it is relevant in the circumstances. Now, my lords, just following on to paragraph 52 briefly, your lordship will see a further distinction that the judge there makes, where a decision maker may fail to take into account such a specific consideration capable in law of being relevant, but to which regard is not required to be had by an enactment, whether especially or by implication. The allegation comes effectively in 2 types. The first arises when a decision maker has had regard to the consideration in question, but has decided it is not relevant to his decision. Now, that is on the face of, well, that is what's happened in our case. And then it goes on, the judge goes on to say, in that case, the decision maker's judgment is one that can be reviewed on conventional public law grounds, such as a misdirection in law, or on the basis that no reasonable person could have taken that view in the circumstances. Now, we say not that these things, we've never said, and we'll come to the reading of the report in due course after lunch, but we do not say that a fair reading of the report as a whole shows that what Mr. Beglin says is correct, that we misdirected ourselves, that we were not able to take into account the material consideration that he wanted us to take into account, namely either intensification or contamination, but rather in the circumstances of this application, and we'll see the language in due course, but you'll remember that Mr. Zamek used the language of in the context of this application, that it's not a matter for consideration.
But if one is to take the methodology of Mr. Howard in paragraph 52, is not Mr. Beglin's argument more the second type of case I referred to?
Well, that's right, and we've said that would be a rationality challenge, and that's
Well, no, the second case where it simply hasn't addressed a specific consideration.
No, that's what he alleges. But
Yes, but I think he would put it into the second type of case, wouldn't he? His argument.
well, in which case he's still within the realms of rationality, and that's.
And I think you would say
We
you would say it's the first type of case.
Well, that's right. That's what I'm trying to. That's just. Yeah.
That's where you and me differ. Yes.
That's why I want to clarify, because there are the two types of cases. But the point really, my lord, is to say that on either basis, he's in the realms of rationality. Mr. Beglin's in the realms of.
Why? If you fail to take into account a consideration you ought to have taken into account, that's not a rationality argument.
Because, my lord, the second category of case is the case that the line of authority here that's being dealt with. It has to be a rationality challenge because the decision maker chooses which material considerations to take into account.
No, a decision to take into account or not to take into account, I agree, would be subject to a rationality challenge. But supposing no decision to take into account or not take account has been made at all, it's just simply been completely overlooked.
Yes, no, but
Then it's not a rationality challenge.
No.
It's just an ordinary conventional public law challenge.
Yeah, but I don't think my learned friend is advancing that proposition because it's not sustainable. We know from the language of the report that the representations
But his core,
that were made.
except although the grounds are put in various different ways, his core proposition is that if you read the report
Yeah,
fairly naturally as a whole, the officers approach matters on the footing that there simply is no power to impose some kind of condition relating to this development.
yes, and obviously we don't agree with that. But we don't. But I didn't understand my learned friend to be saying that that the issue was ignored altogether, because of course we know that conditions were considered, and we know that the representations made.
Well, that's the point you're going to come on to, isn't it?
Indeed.
That's what this appeal is probably all about.
Absolutely, my lord.
All right, well, shall we come back to that at?
Yeah. Thank you.
Should we say 2:05?
Thank you.
How long do you think you're going to be in your submissions, Mr. Sterling-Jones?
It obviously depends on questions, but I wouldn't have thought longer than about 45 minutes to an hour at the most.
Right, well, we'll certainly come to finish within the time allocated. Right, 2:05. Thank you very much.
All right.